If a grantor conveys a fee simple estate subject to a condition subsequent, and the grantee breaches the condition, is there a time limit on the grantor's right to reenter and retake the property? The court had to decide if 60 years was too long in Metropolitan Park District versus Unknown Heirs of Rigney. In August of 1884, John Rigney and his wife conveyed a parcel of land to the Tacoma Light and Water Company. The deed said that the land was to be used for conducting a fresh water supply to the city of Tacoma. The deed provided that if the water company ever stopped using the land for that purpose, Rigney and his heirs and assigns had the right to re-enter the land and repossess it. The water company used the land for water supply purposes until 1893, when it conveyed the land to the city in a deed that contained the same condition as the original deed. The city continued the water supply use for several years, but it stopped in 1905 and began using the land as a park. The Metropolitan Park District began managing the park in 1907, and the city formally conveyed the land to the Park District in 1951. In the early 1960s, the Park District commenced an action against Rigney's known and unknown heirs to quiet title to the property. Rigney's heirs counterclaimed, alleging for the first time that the condition in Rigney's conveyance had been breached, and as a result, the property had been forfeited. The parties agreed that Rigney's original deed to the water company had conveyed a fee simple subject to a condition subsequent, giving Rigney and his heirs the right to re-enter the land if it stopped being used to conduct a water supply. They further agreed that the condition had been continuously breached since at least February of 1905, and that neither Rigney nor his heirs had ever claimed a forfeiture or right of re-entry prior to their counterclaim. All parties moved for summary judgment. The trial court granted the Park District's motion and quieted title in the Park District. Some of the heirs appealed to the Washington Supreme Court.